Sir, with your permission. Sir, with your permission, may we start with the session?
Yes, and please raise a hand if you can hear my voice clearly.
Yes, sir, you are audible clearly.
Okay, thank you.
Research is a compass that guides the mooter through the intricate terrain of the law, while advocacy is the art of skillfully navigating that path, persuading others to see your way. Greetings, fellow enthusiasts of the legal realm. I, Hiba Naz, on Pakistan's School of Law for Women, Jaipur, Rajasthan, am delighted to welcome you all on the second day of the RSLW Second National Moot Court Training Workshop as we delve into the fascinating realms of mooting and research. In today's session, we will equip you with the tools and knowledge to excel in the art of mooting and research. Today, we have with us Mr. Navneet Solanki, sir. Sir, with his impressive qualifications, including a BA LLB and an LLM NET degree, boasts a rich academic background that serves as the foundation for his legal expertise. With 2 years of valuable experience, he has demonstrated his commitment to the field of law. Additionally, Mr. Solanki's expertise as a clerk and a judiciary mentor spanning 5 years underscores his passion for nurturing and guiding aspiring legal professionals. His extensive academic background, combined with his mentoring experience and visionary leadership at Logica Educations, make him a prominent figure in the legal education domain. We welcome you, sir. Before beginning the session, there are some guidelines for the participants. Firstly, all the participants are requested to keep their cameras on and audios on mute. Secondly, at the end of the session, a feedback form link will be dropped in the chat box, which must be filled to receive the participation certificate. Kindly note that the certificates will be provided via Google Drive link on the WhatsApp group within 7 days. Kindly do not leave the group immediately after the session. Thirdly, in case of any misconduct, the participants can be disqualified from the workshop. Thank you. Now, I would request Mr. Navneet Solanki, sir, to commence with the session. Over to you, sir.
Thank you. And I hope that I'm audible to everyone.
Yes, sir, you are audible.
Okay, thank you. Thank you. Thank you. Today's session is about mooting and research. So I will be dealing with PPTs on each subtopics of this session. So just give me some time and I'll open the PPT. There is some issue, just can you please confirm? Everybody can see the PPT?
Yes, sir, it's visible.
Okay, thank you. So thank you for having me in today's session. And extend my gratitude to Mrs. Vartika ma'am for having me today in this session. And I also express my gratitude to the whole faculty members and students who have joined the meeting today. So basically, when we talk about what is mooting, first we should know that what is a moot court competition. So I will be dealing with every subtopic which is mentioned into your course structure. So the first subtopic, which is mentioned into a course structure, is about how to search for a moot court competition for participation. First of all, I would like to tell you that the first ever moot court competition, which was organized in India, was in 1981. It was organized by Bar Council of India, and since then it has been organized every year by the Bar Council of India. So when I was doing my moots in the college, and now I am mentoring students for moot court competitions. Uh, so basically, I have divided my I have divided the moot courts into tier one, tier two, and tier three moot court competitions. So tier one moot court competition is basically of master level, and it includes prestigious moot court competitions which require advanced skills, knowledge of law, and prior mooting experience to perform. So basically, all the colleges which are into tier one and tier two law colleges are participating in it. So it is very important to filter out as to in which moot court you have to participate. So for example, if you are a student of first year and second year, suppose, so you don't have an in-depth knowledge regarding the law subjects. So you should always choose your moot on the basis of your knowledge of law. So if you are good in law of torts and law of contracts, so always go for the moot court competitions which are dealing with the moot problems which are based on law of torts and law of contracts. For example, and on the basis of this division, I have also divided colleges into tier one, tier two, and tier three. So tier three law colleges are those colleges which are situated into tier three cities. For example, Baswada and Bhilwara. If we talk about Rajasthan, tier three city is Bikaner, Baswada. Tier two cities are Udaipur, and then tier one cities are Jodhpur and Jaipur, respectively. So you should always match your tier of city, your tier of college, and the tier of the moot court competition. These three things are very important. It is very important to sync between these three tiers. So if you participate into a tier three moot court competition, tier three moot court competition, tier three moot court competitions are those competitions which are organized for the very first time. So the first and the second editions of the moot court competitions are basically tier three moot courts. So if you are into a tier two or tier one college, and if you participate into a tier three moot court competition, your winning percentage will automatically rise. So basically, at the end, it is very important that you should win. It is important that you should have your experience, that you advance into your argumentative skills and your researching skills. But then as you are participating in a competition, it is also very important that you win the competition as well. So always match these things and always try to, hit and try method so that you can excel into the moot court competitions. So if you are a tier one student, suppose, and you are living in a tier one city and you are also studying in a tier one college. Now, these three things will very easily get you into the prestigious moot courts. For example, Surana and Surana. And similarly, if you are a student of a tier two college and you are into a tier one city, if you target tier one moot court, then it is very important for you to research on the level of tier one cities teams, because the exposure of the teams and the quality of the participants who are participating into tier one level of moot courts is also a point which is to be considered. So it is very important when you select a moot court competition for participation that it should be a moot court on the basis of your experience, on the basis of the infrastructure which your college provides you with. And the third thing, it should always be looked into that it is a tier three, tier two, or tier one moot court. Okay. And then we have certain points which are to be remembered always when you choose a moot court competition. The first being that you should always choose a moot based on well-read or familiar law subjects, as I have earlier stated. if you are well versed with the law of crimes, always go for a moot which is based on criminal law. Then the second point is that always see that you get enough time for the preparation of your moot court competition. If you want to prepare for a moot court competition, you have to see that you get at least 1 month of time. At least 1 month of time is important when you go for a moot court competition, because preparing of the moot memorial, it is very important that you get a certain amount of time. If you talk about me, I would say that it is at least 2 months. But then I have seen people who have excelled in their moot courts and they have prepared for at least 1 month. Then the point being that when you are choosing a moot, it should be based on your competitive mooting experience. As I have mentioned earlier, that if you are a student studying in your tier 3 college, then you should not go for moot court competitions which are tier 2 or tier 1 based. If you have any questions, students, you can ask me, or we can take questions at the end of the session. Then the next point being that moots which have had previous editions and versions before, you should always choose the moots based on their previous editions, because these moot court competitions are also part of your CV. They will go into your CV and they will reflect that what sort of exposure you have had at the level of your undergraduation degree. When you were studying law, what sort of exposure did you have? Then coming to the next point, it is very important that you should always choose a moot court competition which is releasing its moot problem with its brochure at the very same time. Always try to select that moot court which pre-releases its moot problem with the brochure, so that you get the hold of the moot problem, and then you can decide that whether you want to participate or you don't want to participate. Then the next point being, check your academic schedule as well. Your moot court competition should not clash with your internal exams or your external exams. Always look into it, because you don't want yourself to get overburdened. Then the next point being that select the moot with the consent of all the team members. See, we are going to discuss about the team members in the later stage of our session. But then when you talk about the team, it has to be a common consensus. It has to be the consent of every team member, whether they want to opt for that moot court or they don't want to opt for that moot court. So you should never push your team members to choose a moot court which they don't want to participate. So this is the basic outline, the basic division which I have experienced in my span of mooting and my span of mentoring students, regarding that you should always divide the type of moot court. You should link this and sync this with your level of college and the infrastructure which you have at hand, because it is very tough to find libraries and it is very tough to find online sources, because I have seen in many colleges there is a lack of online resources. The online resources such as SSC Online and Manupatra and Legit Quest and the online sources like these. And you cannot rely on the free platforms which provide you legal database and legal materials related to your case and the law subjects. So you should always see that what your college can offer you, what is the demand of the moot court competition, what is the level of moot court competition, and what sort of students and what sort of colleges are participating in that moot court competition. Because at the end, if you are mooting and you have, suppose you have mooted for 3 years and 4 years in your 5 years of BA LLB or BCom LLB, you would want that you win at least 1 or 2 competitions which you have been participating in. So always remember these points, and if you want, I will share this PPT with the concerned faculty, and they can give you this PPT. So always look into it and remember these points when you select a moot court competition for participating. Now the second point is that what is a moot problem and how to read the moot problem. So the moot proposition is basically any hypothetical situation, or it can be a situation which is inspired by a real incident, but majorly it is a hypothetical situation which is based on various facts which are in contravention with each other. So it is basically a hypothetical situation which is created for both the sides so that they can argue their case from both the sides. So it is not going to be a single-sided problem. It is always going to be a balance of contraventions between the facts so that you can argue from both the sides. It is typically set in the areas of law that are unsettled or that have been subject to recent developments. So you will always see a moot problem which is based on the recent developments which are found in the legal area. It can relate to any law subject. There is also one point which is very important when you see a moot problem as to how to read it. A moot problem will always, if you see a moot problem, it is not talking about the stage of trial. It will not set any fact which is related to the stage of trial. You will see the facts which are in contravention. You will also see a decision of the lower court altogether. Then that decision is challenged by way of an appeal or by a petition into High Court or the Supreme Court. So basically, a moot court is different from an advocacy trial. You will see the stages of trial. For example, your examination in chief, your re-examinations, your witness statements, and all the reports and all the evidences which are presented in front of the court. You will see these things and the procedure which is followed by the lower courts in advocacy trials. But then it is different. The whole scenario is different when it comes to the moot. Moot court, the only thing which is tested is the ability of drafting, which is obviously, numbered and marked on the basis of your moot memorial. Then the second ability, which the competition organizers are seeing, is that how well do you argue? How well do you connect your thoughts, connect your legal reasoning with your memorial, and you present the case based on the facts. So it is different from an advocacy trial. Now, I have, divided a moot problem into certain stages. The first stage being the preliminary facts. Now, the preliminary facts are those facts which are basic and they introduce the parties which are at dispute in a particular moot problem. Or these are those facts which are very basic and introductory in nature. So these facts are not very important and significant. However, you should always know the parties which are at dispute, but then these facts will not be in direct contravention with the cause of action or the legal discourse, which is being opted by the parties. Then there are the main facts. These are the facts which are significant to the moot and depicts the actions and reactions of the parties at the dispute. At the later stage of the session, we will discuss all these things with the help of an example. Then I have divided the third part into the cause of action. What was the cause of action? What was the reason behind a party opting for a particular legal discourse? Legal discourse is basically the legal rights which are invoked by the party. Suppose a party is aggrieved by the impugned order by the impugned order of the lower judiciary, lower courts, then they are obviously going to file a petition or an appeal. So this is called a legal discourse as to what legal remedy or what legal right is being opted by the parties and defended by the parties. Then there are arguments at the lower courts, the arguments which were presented by the parties when they were arguing at the stage of the lower judiciary, lower courts. Then there is the lower court's decision, which would be either in the favor or which would either be in the against. Then there are the details of the appellate court and the grounds of appeal and jurisdiction of the appellate court. These points are really very important because when you are drafting your moot memorial, the very first stage, the very first point is that you have to mention the jurisdiction of the court as to whether the jurisdiction of the court is maintainable or not, whether the jurisdiction which you are trying to invoke is maintainable and can be entertained by the court. So, for example, if you want to file an SLP, so SLP is filed under Article 136. Under Article 136 of the Indian Constitution. Now, on that case, you have to, when you are filing an SLP, you have to see that whether it is maintainable or not, whether it can be filed or not. Because there are certain restrictions when you have to file, when you can file an SLP. Now then the last part is, which is always being mentioned at the last point, which is laws and issues which are involved in the case. So you have to mark all these things, and you should always divide your moot problem on the basis of these bifurcations which I have made. If you do these things, it is going to be a cakewalk for you guys, so that you can always maneuver your problem into your favor, and you can also bifurcate that whether you have to argue on behalf of the prosecution, or whether you have to argue the case on the behalf of the petitioner, or you have to argue the case on the behalf of the respondent. So this is the way that you should see your moot problem, and you should try to read it. Now let's go further. Now I have developed two techniques which you should always keep in mind. The first technique being, you should always read and revise and repeat this process till the day you are starting your arguments in front of the court. You should always read it, always revise it, and always repeat this process, because 60% of the questions which are being posed by the judges are based on the moot problem's facts itself. They are not going to question you on the law. They are not going to question you on any other thing. They will question you first, and the foremost thing is that they will ask about the facts, because they want to know that, have you thoroughly read your facts? Do you thoroughly know the response which your client wants and which your client is offering? So now you should always talk about your facts between your team members. That is why I have written that you should gossip about your facts. This step includes reading the moot problem n number of times. You should always read the moot problem. You should have a copy of the moot problem with you everywhere everywhere you go. Now then you should always, while reading the problem, try to create a timeline of the events. Para-wise, suppose your problem is divided into 10 paras. So now in the para 1, if you have a timeline not only specifically talk about the date. It can also be the month, it can also be the year, and it can also be a certain events or a transaction of events. Okay, so you should always try to timeline the events para-wise, so that it is easy for you to remember, easy for you to revise, and easy for you to memorize the facts. Then while you are timelining the events, try to find the law which is in question. If you find that there is a certain discrepancy between the laws and between the facts, always try to mention the law which is in question. Now then, there is another technique which I think has been fruitful for me, and which is fruitful for my students as well. I have divided this tricolor technique into 3 colors. The orange color are those facts. Once you have read your moot problem, it is now important to prioritize the facts which are in favor of you and which are in against. Okay, so now suppose it is very obvious that you don't know from which side you have to argue. It is only after the draw of lots that you know that you have to argue for the petitioner or you have to argue for the respondent. So now, for example, those facts which you think are of priority, you should mark them with orange color. Simple. If you don't want to write, just mark them with orange color. Then there is green color. Green color denotes as to those points and facts which your opponent will resort to. You should always think from the side of the petitioner and from the side of the respondent as well. So always try to question your fact, always try to question your solution with another question, so that you can find any loophole. If there is any loophole, you can find that thing. Then there is the blue color line. Blue color denotes if you find any issue which is of prime importance, if you find any issue which could be a tentative framed issue into your moot memorial, because not every moot court competition involves issues. There are some moot court competitions which will, they give you freedom to frame issues, so that you should use this technique while you are bifurcating the moot problem and while you are reading it. If you combine these two techniques when you are reading and revising, While you are reading, just apply this triangular technique. It is going to be very useful for you. Now then, moving further, this is an example. I have created a, small fictitious, mood problem. It is X and Y got married on 1st of January 2020 and were living a happy life. They have one son out of such marriage. So now, see, these are those points which are the prelims facts. X and Y are married, and they got married on the 1st of January 2020. So this is a basic introduction about X and Y, that they are married. They also have a son. Now then, after 3 years of marriage, quarrel between them started. Now the main fact is that after 3 years of marriage, quarrel between them started. So by these points, you can now bifurcate that what is the situation and what is the issue between X and Y. One day the husband slapped her wife, and wife left the matrimonial house and went to her parents' house. Now, this is the cause of action as to why one party separated from the other party. It was the act of the husband of slapping her wife, and because of that, wife left the matrimonial house and went to her parents' house. So this is the cause of action. And now, what is the legal discourse which we have discussed is that after 2 years of separation, husband filed a divorce petition on ground of cruelty and desertion. Now, students, look into this, that the husband is filing the divorce petition. And it is a very well settled ground that if you are the wrongdoer, if you have committed any offense, if you have done anything wrong, you cannot seek remedy against the person who has been wronged. So now, this is the legal discourse which is being filed by the husband. Now, the part of the lower court's decision comes. The lower court, on the contrary, rejected the ground of cruelty, because it was found that husband has committed cruelty, but then it allowed divorce on the ground of desertion. So now these two things are in contrary with each other, and they do not sync with each other, because it has to be taken into one point by the lower court. So this is the impugned order which is being further appealed by a wife in the High Court or in the higher court. So these are the bifurcation, and this is the way you should divide your problem. And issues and laws involved in the case, as you have read the problem, now you can obviously get into the things that which are the issues which are in question, and which are the issues and what are the key points which you have to look into and search for while making your memorial are desertion, cruelty, divorce, matrimonial house, and as to under what is the period, what is the minimum period before which you can file for divorce. So these are the certain points, these are certain grounds on which you can start making your arguments. Now in further session, we will discuss that as to before starting your moot memorial, what should you do and what are the things you should timeline and streamline so that you can make a good memorial, because memorial is the spine of the speakers who are going to present their arguments in front of the court. Because if they don't have a memorial which is well versed with all the facts and laws, the speakers will not get into a comfortable position while arguing in front of the judges. Now, when we talk about the speakers and the researchers and the team members, now how to form a team and what is the role of each team member? Now, traditionally, if you see, the most common formation of the moot team is that you have two mooters. They argue on the issues respectively, and then you have a researcher. Researcher also has, a very important duty, which I will discuss in the further session. Now, let's talk about formation of the team. Now, when you talk about a team, the first thing is that it is not important that you make a team of friends. No. You should always see that you have a basic, the least amount of thing which is important is that you should always see the cooperation, compatibility, and commitment towards work. So it is not necessary that you will find these qualities only between friends. Sometimes it so happens that friends are not very cooperative. They take you for granted. They can also try to overburden you with their own responsibilities. So it is not necessary that you form a team between friends. You should always see that you have a common interest, and then on the basis of that interest you form a team. Now then, person who is ready to accept. Now the thing is that you should always sorry, you should always put your opinions in front of the team members, and contrary-wise, you should also listen. So it is very important to maintain this balance, to maintain this sync between of hearing, listening, and talking. So between these three people, you should see that all the three people put their opinion in front of each other, and they also listen to the opinions of the others as well. So now, coming to the further point, the first is that you should always see that all the team members share a basic, share the same interest. So, for example, if the mooter one is interested into, for say, criminal law, and the mooter two is interested into contract law, and the researcher is interested into some other law, for example, you say constitution. Now, these three people, they will find it very hard to come on a consensus as to in what in which moot to participate. And then even if they select a moot court competition, due to their personal biases related to a particular subject, they will not get into research very easily, and they will not perform with their full potential. So, and then it will become an impediment when the work is to be divided, because it is not the responsibility of the researcher to make the whole memorial. It is also very important for the mooters, for both the mooters, to research on a particular issue, and the work is to divide, and the work is to be divided in such a manner that it is very comfortable for all the members to work in sync. Now then, the most important thing I have seen between students is that they are not very open to role reversal. Role reversal means that if you have participated into one moot court competition, for say being a researcher, so you should also try to participate in a moot court competition being a mooter, because you don't have to only develop and advance your capabilities related to researching only. Because for a lawyer, for a practicing lawyer, or for any legal fraternity, it is very important that you should have a developed writing quality. A writing quality, speaking ability, and then the third is that of researching. So if you are good at researching, you will automatically be good at writing and speaking, because if you have researched and you have read, then it becomes easy for you to speak and to write. But then if you only know about speaking and writing, you will not be developing your ability of researching, because these three things are equally important when you talk about practicing, or when you talk about for say doing any job in the legal field. So you should always be open to the trait of role reversal. Try to participate in moot courts in all the capacities. Try to be a mooter and try to be a researcher as well. So this is the way you should form a team. And now the role of each team member is that you should be dividing your work equally, so that no one member is overburdened. Because when you frame your, when you frame your initial draft of your moot court competition, it is not final. After framing your initial draft, you have to read it, then you have to format it. So now this reading and proofreading and this formatting wala jo part hota hai, it becomes of the researchers. But then if you give the researcher a blank paper and you say that you have to draft the memorial from the very beginning and to the very end, it will become a very tough for the researcher. Obviously, it will enhance the qualities of researching in the researcher, but then it will not help you as being a mooter, because you also should, you don't have to just memorize the memory. You also have to look into the facts. You also have to look into the law. You should know what are the material facts, and you should also know that what are the immaterial facts. So it is very important. As you all have read in the Indian Evidence Act, there are relevant facts and there are issues which are relevant and issues which are in question. So these are the things which you have to see when you are making a moot memorial, and when you are preparing as being a mooter. If you have not researched, or if you have not, synced with the researcher while doing the research, it becomes very tough and a very tedious task at the end when the whole memorial is made of 30 to 40 pages. And when you are seeing your part, then you have to research at that time. So it is important and it is advisable that you start from the very beginning and you take your part as to this is the part which I am going to research on and I will prepare the arguments. Then the mooter too will take his part. Then the researcher will research on the things and on the facts which are being left and which are not being taken. So this is the role of each member, of each team members. The only trait for being a successful team is the division of work and commitment. So these are the only things, because you get a very short span of time, you get a very limited span of time in which you have to prepare yourself, and then you have to also prepare your memory. And you just don't have to prepare for the preliminary rounds. You will obviously prepare for the final stage. Now, for example, I think you all know that when you participate in the preliminary round, you get a short span of time for arguing. So in the preliminary rounds, you have to only state those facts which are, you have to state only those arguments which are very centric to your presentation. Then when it comes to the quarters and the semis, you get a time period which is around 20 to 25 minutes. Then at that point of time, you can use the facts also with your arguments. And when you reach the final stage, you get around 30 to 35 minutes of presentation. So at that point of time, you can start with the facts from the very beginning, and then you can link all the arguments and your legal reasoning and your evidences or anything which you have found while researching. So you have to see that at the stage of preliminary, at the stage of prelims, you prepare yourself in such a way that you can put all your thoughts, all your arguments in that 15 minutes of span. So while forming a team, you should always see that you have to take a person who is good in speaking, who can very easily put his thoughts in front of the judges or in front of anyone. And when you choose a researcher, you should always see that your researcher is well versed with all sorts of sources which are offline and online as well. So now let's move forward with our presentation. Now, what is the role and importance of a researcher? Now, as we have discussed about the mooters and the speakers, now the most important part of your moot court team is the researcher. He is the person who is responsible for the formatting of the memorial, for the final draft of the memorial when it is made before submission. He is the person who is responsible. So you should be very, very comfortable with all sorts of techniques which are to be implied while you are formatting your memory. Now then comes the point of appearing for the researcher's test. Now researcher's test is basically a test which is organized before the prelims rounds. And this test includes questions based on the facts of the case. So this is important when it comes to the researcher's test, that researcher also has to read all the facts thoroughly, so that if any moot court competition organizes any researcher's test, it is very, very beneficial for your team if you score good in the researchers test. In those moot court competitions in which researchers tests are organized, it generally comprises of 100 to between 100 and 120 marks. So this is a whole lot of marks which you can cover, and you can help your mooters and your team so that they can find themselves into a good position when they are going to argue in the prelims rounds. So always try to select those moots. If they have researchers test, then pay special attention, and specific detailing has to be done when any moot court competition is being organized which is related to researchers test. Now, researchers lessen the burden of research of the speakers. Obviously, it is important. Now, the researchers have a very specific duty that they are the responsible person if the speakers are not able to find any point which they are looking for. Suppose if they are trying to find a law which is in direct contravention or in support of the fact. Now you want, suppose now you want the relevant case law. Now, if the speakers cannot find, the researcher has to nail it. The researcher has a very prime duty that he has to find that particular point, that particular relevant case law, so that it can be of help for the mooters or the speakers. Now, how to see that a person is good in researching, or he or she has good traits of researching. Now, the researcher should be able to find out relevant case laws, as I have mentioned, and using the right keywords. Now, keywords are those words which are used while researching. So, when you use your online platforms, the online platforms, as they are all based on the AI, they will automatically filter out all the judgments which are including or which are inclusive of that particular keyword which you are trying to find. Now, obviously, it can be advanced to another level. You can also filter those keywords on the basis of date, on the basis of one, and on the basis of citations as well. Now, then the important part is that a researcher should always be able to read the judgment quickly. Now, how to read a judgment quickly? It is very easy. If you are using an online platform, just use the keyword, use all the filters which your online platform caters to. But then if you are using any offline source, now how to read a judgment efficiently and quickly when you are using a offline source? Now, I would like to state that offline sources also contain filtering options. If you see a book, see a book, at the end, you have glossary, you have all the important keywords and the words which are being used on different pages, and they are mentioned that this word has been mentioned on this page number. Now, similarly, when you see, suppose we take an example of AIR. Now, you want to search a judgment from AIR. Now, how to do it quickly? Now, suppose you have searched a particular judgment, a particular keyword, you have found out a particular keyword. Suppose common intention is your keyword. Now, there are several of judgments in a particular AIR which would be inclusive of the word common intention. Now, how to do that if you, in case you are using offline source? Now, there's an option of head note in every judgment. Now, try to read the head note of the judgment. So, head note is basically a sort of abstract. It will automatically tell you that whether your searched keyword is useful and whether that searched keyword in that judgment will help you or not. So always try to read your judgment quickly, and these are the ways in which you can develop as a researcher your traits of being a good researcher. You can develop your researching skills. Now, the part comes that what is the important part which you have to take into your memorial so that you can use it efficiently. Now, you cannot quote the whole judgment. Suppose a judgment is of 15 pages or 20 pages. You cannot take the whole judgment. You have to take only that part which is of use to you and to your moot code, to your moot problem. Now for this, head note will help you. As I have mentioned, it is like an abstract. It will help you. Then you can directly scroll to the area where the last part, it is written that what was the stance of the court in that. Now, according to the stance of the court, you can easily determine whether that this judgment is going to help you or not. You don't have to read the facts. You don't have to read the arguments. First, just read the judgment which the court has held. If that is of use, then try to find something else by way of reading the arguments. Now then, the most important thing is that as everything is going online and everything is, AI driven, you should develop your skills of online researching. There are many platforms, and we will discuss these platforms, Yeah. Sorry for the interruption. Okay. Now the next point is knowing the required citation methods. Also, some of the moot court competitions, they mention what sort of formatting is to be done, what sort of citations is to be used, and what sort of, if any footnoting is to be done, how it is to be done and how it is to be cited. So these are the things which a person should inculcate in him or her so that they can become good at researching. Now, what is the work which is being carried out by the researcher? As we have mentioned, and as I have, continuously I'm saying that you have to develop your online researching. So now these are the legal databases. Suppose, for example, Manupatra and SSC Online. These are the online legal databases which are offering a wide range of relevant case laws, wide range of periodicals, wide range of research papers, nationally and internationally. SSC Online, you will find all the Supreme Court judgments, all the judgments of the High Court, all the judgments which are of relevance to you. You will find it over there. But then you should know how to use these platforms. Now, most of the colleges these days have access and subscriptions to Manupatra, SSC Online, and there are also different sorts of online platforms. So for example, Legit Quest, then there is Hein Online. So these are the platforms which can be of use while you are doing the research. So it becomes very tough when you have to, pursue your research from offline sources like books. These platforms cut your time, and these platforms help you in such a way that you get your exact, point which you are being searching. So these, so this is the important aspect of using the online legal databases. Now then, the second point is that reading and citing the relevant results. Then it comes that what is the accurate formatting which is to be used while making the moot memorial. This is also a duty and task which is being assigned to the researcher. Then there is researcher's test, increase the chances of the team. Then there is following of the court mannerism. So if you suppose if you are a researcher and your speaker, your the member, the counsel is arguing in front of the judge. Now, if he wants to be aided or assisted, or assisted in any way, this is the thing which is the prime duty of the researcher. If you know whether your speaker or mooter could be helped, you should always take the permission of the bench and only then proceed. A researcher should never act on the basis, the researcher should never act without the permission of the bench or the judge. Then there is one, important aspect that you cannot include all the things into a memorial. So there is a supportive document which is prepared by the team, and this called compendium. Now, then inside a compendium, you can always put all your judgments. If you want to put the whole judgment, you can put that whole judgment into the compendium, but you cannot include that whole judgment into your moot memorial because it is only of 30 to 40 pages. So a compendium and its preparation is also the duty of the researcher. So these are the traits and the role and the importance of a researcher into a team. So in short, I would say that the researcher is basically the spine of the team because he is the person who has read all the facts most number of times, who has read everything, who has read everything, not only the issue of one speaker or the other speaker, he reads everything from the beginning to the very end. So to have a sound researcher, it is very important. Now let's move forward. Now, if you are a researcher, you have to begin your researching from somewhere. So now, how to start researching from the beginning? So now, as I have mentioned, before also that you should bifurcate your facts and you should bifurcate your moot facts into various categories of preliminary facts, main facts, course of action. Then you should the researching basically starts when you have framed your tentative issues which you are going to research on. Because if you have not framed the issues, you cannot initiate your legal research. So now, how you can frame your tentative issues? The first being that you should know the core dispute between the parties. Then the second point being that you should also know the parties and their contentions. Then you should know the legal issue and the relevant law which is to be searched. Because if you don't know the law which is to be searched, you cannot start your researching. Then you have to divide the issues among the members of the team. So if you see that, suppose there are four tentative issues which you have to frame. Now divide these issues. Divide these issues in such a manner that every team member has equal balance of work allotment. Then start, then start researching on your particular issue which you have been, allotted, and then try to draft a skeletal argument which is either in favor or it can be against. So you have to draft from both the sides. You have to draft in favor also, and then you have to draft against also. So, and I'm saying it skeletal because this is not final. This is only the law, the issue, and the parties' contentions, and the syncing of the facts of the moot problem with your particular issue. That is why we call it skeletal argument draft. Now, further, the research should be done in line with the tentative arguments to be framed. Now, what you have to present, you should always draft your arguments according to your presentation, which means that if you want to put a particular point, you should always use the language which supports your contention. Now, it so happens that judge will try to confuse you. He will try to, divert you into the area which you have not mentioned into your moot memorial. But then it is very important for you to stick on the point which you have mentioned and and simultaneously try to solve the issue or the doubt of the judges. But then it is of prime importance that you stick to the point which you have mentioned in your memory. Now, how to draft this skeletal argument? Now, the first thing is that obviously you have been allotted the issues. Now, it will start from the point of framing of issues. Now, then the second point is that you have to research and find a probable solution to the issue. Now, what are the laws? What legal reasoning will either be in support of it or will either be in denial of it? So you have to find a solution so that you can support it as well as you can deny it as well. Now then, the grounds for such solution. Now, if you have found out a solution, what is the ground and what legal discourse can be opted for providing a particular remedy for your side? And after that, start framing your arguments. It is not important to use specific legal language, specific language which is used in the court of law. It is just a skeletal argument. Just write your arguments, and at the time of the final stage of the draft, and at the time of the final formatting, you can edit all your language, and you can sync, and you can streamline it according to the legal language which is being used. Now, for example, suppose you have a problem, and this is the issue which is being allotted to you. Now, whether denial of paternity leave to a male employee is violative of Article 14 under Indian Constitution. Now, you have to find a solution which is supportive. Now, this should support your argument. Your solution should support your argument, should be in favor of the petitioner. Now, what is the supportive argument? That this is violative of Article 14 with respect to the male employees in connection with the granting of the paternity leave. Now, what could be the grounds of such solution? Now, the first ground could be that you can research about that this action amounts to discrimination based on gender. Then the second ground could be, which could be researched and which could be found out, is that the action doesn't create a reasonable classification between male and female employees. This is not intelligible differentiate. There is no intelligible differentiate. Then the office policy amounts to class legislation. So these are some probable solutions which could be in support of your arguments. So this is the way, this is the technique of drafting a skeletal argument draft, and you should always draft this skeletal draft, you should always draft this thing before you move on to the final drafting of your moot melody. Always try to draft this thing first and the foremost, starting from your allotted issue and then linking it with the facts of the case and the relevant case laws and the legal reasoning. Now, moving forward with the session of there, now what is ideal argument framing? Now, once you have reached the stage of argument framing, now there are four important parts of argument framing. The first one being that it is the issue, as we have discussed. Determining of the issue is the most important point, because if you are not able to determine a particular issue, you cannot suffice your legal reasoning when you are going to present your case in front of the bench. So it is important that your determined issues are in sync, are in relation with the moot problem. You cannot take an issue which is not even, which is not even into question in the moot problem. Now then, after determining the issue, you have to search for the law which is in support and which can also deny this possible, condition of your chosen issue. So it is called as rule of law. Now this law is to be searched out, and it is to be researched as to why this law, when it comes into the relation, is being questioned in this particular moot problem. Now then comes the stage of analyzing your argument which you have prepared by joining the issue and the law which you have searched. Now, when you analyze it, analysis includes studying and researching about the law and the latest legal position. It is very important to always find the judgments which are being pronounced by the Supreme Court, because it is binding on every court. But then if you, and also at the very same point, also try to find the judgment of the state high court in which the problem occurs, in which the moot problem is based. Suppose your moot problem includes the state of Rajasthan, and your particular issue, as we have discussed before, is of violation of Article 14 with the male paternity leave. Now you have to search for the arguments, you have to search for the case laws which are being pronounced by the Supreme Court, and at the very same point of time, also search for the judgment, if any, pronounced by the state of by the High Court of the state of Rajasthan. Because these judgments will create a binding effect when you present your case. Now, at At the end, when you have combined your issues and the law and your analysis, you will come to the conclusion. And in the conclusion, you will summarize all the arguments and all the legal reasoning which you have framed with respect to with respect to each side, because you have to prepare in favor and in against this. So this is the way you draft your arguments. So, and when you follow this process, it becomes very easy for you to streamline the whole argument and the structure of the skeletal arguments draft. Now then, there are certain strategies which a researcher or the mooter of the team can employ while researching. Now, the first being that laws related to the case. Now, you will always find and you will always research for the cases which talk about, which prima facie talks about violation of Article 14, and at the very same point of time, it also talks about the point of legal dispute. Then the second point being that filter relevant research material. Now, suppose you have searched for the case, you have searched for the law, and you have also searched for your arguments. Now, case laws are not only important. They are also important, but then they are not the only sources. You can also refer to the periodicals. You can also refer to the research papers. You can also refer to the commentaries. Then searching for the relevant case law, as I have told you, you should move from Supreme Court to High Court, and then if your moot problem discusses about any instance which includes supporting or denying of the fact in relation with any data, you should also use useful data, and you should always take data related things from website which are being backed by government or government organizations, or those NGOs and associations which are being recognized at national level. So this is the way you should start your researching, and this is the way you should come to an end while you are, concluding your research. So this is the thing you should keep in mind while you are being a researcher, while you are being a mooter. And these are the important traits and features of a good skeletal argument draft. It will help you while you're final drafting. Now, what are the sources and books for research which you can always rely on, which you can always use? Now, as we have talked about those things which are important while researching, online and offline resources both are important. But then, what are the sources which you should always keep with yourself? Now, the first being that you should use a bare act. Once you have determined as to which law is in question, you should always have a bare act with you, so that you can always refer to the bare provisions. You don't have to, Google it, or you can take a printout of it. But then you should simultaneously attach your important documents with your moot problem while you are making the skeletal arguments. Then you can read the research papers. If you want to see and if you want to filter out that which research paper is of use, you should use the abstract for filtering relevant research papers. As I have discussed earlier also, there are many online platforms, SSC Online, Manupatra, LexisNexis, Taxman, and Online, and LegitQuest. These all are paid platforms. So they offer you wide range of filtering and wide range of options to boil down your point of research. But then if you are not having access to these paid platforms, what is the way of using these free platforms? Suppose Indian Qanun is a free platform, but then it does not offer you filters related to keywords and filters related to date and everything. But then if you are very well versed with the way of researching, you can also use Indian Qanun, and you can always use keywords as well. Now, if you use Indian Kanun, you just have to put a hash, you just have to push a hashtag, and then without giving any space, you just have to write the keyword. And then after, when you press the search button, it will automatically filter out all the keywords and all the relevant judgments which are being using or which are being quoted with that particular keyword. But then if you have to search, suppose 7 or 8 keywords, this method is not of use. So this is the shortcoming and this is the downfall of the free platforms. Now, then it comes that relevant academic books and commentaries on the subject matter. You should always filter out and you should always, uh, select the books which are going to be of use. Now, suppose if you are searching for IPC, I know that you can easily search all the sections on Google and take a printout, but then book also helps because books contain the sections. They also contain relevant case laws. They also contain legal reasonings and the explanations as to why a particular section was drafted by the drafters of the particular act. So this thing is not very easily available on the online resources, and this is the importance of book or a commentary, because you get a first hand on the reasoning of a particular person who has written the book, and you can use that reasoning while making your moot novel. Now, how to use these online sources? If it is paid, as I have told you, you can obviously use the keywords and the filtration options for sorting your particular material or the particular issue which you are being searching for. But then while using the free online sources, filter the keyword manually. You have to filter the keyword manually. Then you have to, now suppose you get a particular list of all the relevant judgments. Now, into this also, you just have to read the head note and simultaneously bifurcate all the relevant judgments from the judgments which are not relevant for your particular issue. But then even if you are not very well versed with the searching technique by using keywords on the free online sources, you can always download a particular judgment, just open it into a doc file or a PDF file, and then search in that particular doc file or PDF file. You will get that particular keyword highlighted into yellow or red, whichever color has been set as default. And then at that point of time, you can read the judgment and the abstract or the head note of the particular judgment. And for credible data accumulation, always use government websites for quoting or putting or including any data which you are thinking of using to suffice your points, to suffice your issue. So this is the whole presentation from my side. If you have any question or if anybody has any question, the session is open and you can, from my side, I finish my session for today. I think I'm audible.
Good morning, sir. My name is Dipanshay. I'm from Moody Law College. I have a query. Why is it needed to create a skeletal argument draft on both favor or against?
Actually, the thing is that when you enter into a moot court competition, you don't know that from which side you will be arguing the case. It is only after the draw of lot that you know that from which side, either from the side of the petitioner or from the side of the respondent, you are going to argue. So now, if you have to, similarly, if you don't know the position from which side you have to argue, it is very important at the time of drafting of the memorial, and it is also a condition that you have to submit the arguments both from the side of the petitioner and from the side of the respondent. So while you are making the skeletal argument draft, if you bifurcate your reasonings on the basis of both the sides, it will be easy for you, for you and your team at the end when you are going to draft your final memorials. So that is why I am stating that it is important for you that while you are into your skeletal argument draft stage, you draft from both the sides. I think Gitanjali, your doubt is solved.
Yes, sir. Thank you. My next question is
Sorry.
Good morning,
the
sir.
topic for
Sir, my
MOOT.
name. Good morning, sir.
Yes.
Sir, my name is Udesh Dakad, and my question is that, sir, if writ petition is filed in High Court and the court decided in favor of respondent, what jurisdiction would the petitioner use? A writ petition or appeal under 132 or SLP in Supreme Court?
See, UK 132 is specific about its criminal jurisdiction and it is specific about its civil jurisdiction. Okay. So SLP is opted because it caters to all the impugned orders which are based on the criminal or which are based on the civil or the original jurisdiction of the court. So most of the time it is used in most of the time it is used in that way. So most of the time parties opt for SLP because there is no foundation of this jurisdiction thing. You just have to prove your point as the prove your point that your SLP is maintainable in front of the Supreme Court.
Thank you, sir. Thank you, sir.
Okay. Does anybody have any?
Yes, sir. I have one more question. The topic for
Yes,
MOOT court will be related. The topic for MOOT court will be related to the past cases or made by the authorities.
Sorry, can you please repeat your question?
Yes, sir. The topic for the MOOT court will be related to the past cases or made by the authorities.
You are talking about the moot court competition which is being organized in the college.
ये तो उसके जो टॉपिक्स होते हैं वो कहाँ से मतलब
अच्छा.
जो पास के
Okay, okay,
केसेस
okay.
होते हैं
So,
उससे रिलेटेड होते हैं डमी
see, while I was presenting the case, मैंने state किया था कि when the moot problem is drafted, it is basically a hypothetical situation. But sometimes it so happens that it is inspired from real incidents, but in majority of the cases, the facts are hypothetical and they are the facts are fictitious. So you will not find any real case being made into a moot problem, because then if a real case is taken into a moot problem, it will become very easy for the participants to take stance. That is why a moot problem is always made on the on the basis of hypothetical situations.
ओके सर थैंक यू
Okay. Does anybody have any questions?
So that you talk about the test of researcher before preliminary round. So, sir, what type of
Yes.
questions were asking in test of
See,
researcher?
Ulfa, thank you for the question. When you talk about a researcher's test, it is basically based on the facts of the moot problem. Okay, so as we have discussed about a small situation while I was presenting X and Y were married. So in that example, a researcher's test will include what is the relation between X and Y? For how many, for how many years were they married? So all these facts, which are very, centric to the moot problem, will find their place while they're asked in a researcher's test. So the the center part is that those questions which are related to your preliminary facts or the main facts are asked in a test of researchers. Is it fine, Alpha? Does anybody have any question? Um, Is anybody willing to ask any more question, or else we can conclude our session?
Thank you. Thank you. Thank you, sir, for generously imparting your wisdom and enriching us with your valuable experience. It was pleasure listening to you. Now, I would request all the participants to switch their cameras on for capturing this moment. Thank you, everyone. Now, like to invite Ms. Nirupama Gehlot, ma'am, member organizing Now, I would like to request Ms. Nirupama Gehlot, ma'am, member of the organizing committee and assistant professor, Rajasthan School of Law for Women, to deliver vote of thanks.
Thank you, Hiba. Greetings to all. It is my privilege to propose vote of thanks for session 2nd of RSLW 2nd National Moot Court Training Workshop. I, Nirupama Gehlot, faculty, Rajasthan School of Law for Women, congratulate you all for being part of this exemplary session on mooting and research. The session was very engaging and helpful for budding lawyers. It is rightly said that a good research is an inseparable part of mooting. In present times, where there is immense of information available, to find that right information is what is research all about. Digging out that one case law which will make our argument invincible is a great satisfaction on its own. I give my sincere thanks to Mr. Navneet Solanki for sparing time out of your busy schedule and enlightening us about the topic. You have surely added to the charm of the event, sir. I would like to thank our principal, Dr. Vartika Arora ma'am, all faculty members, volunteers, and last but not the least, our beloved participants for making the event a grand success. Once again, I thank one and all present here. Thank you.
Thank you, ma'am. Before ending the session, a reminder for all the participants.
Hiba, sorry to interrupt you. I just want to say one thing. One more thank you is remaining, that is to Nirupama ma'am for proposing a vote of thank. And yes, Navneet sir, I've heard entire session of yours. It was actually fruitful. It will be definitely helping the student and participating in various moots, upcoming moots. So thank you so much for accepting our invitation and being here. Thank you, Nirupama ma'am. Thank you, Hiba.
Thank you, ma'am. Before ending the session, a reminder for all the participants to fill out the feedback form in order to receive the participation certificate for the workshop. Thank you all for joining us. The next session will start at 12. Kindly join on time. Hope to see you all in the next session. Thank you.
Thank you.